Well, hello there, everybody. Thanks for being with us today. This is Legal Talk. I am your host, John Mitchell. And today we have a very, very special guest with us. Let me tell you this, the great American poet once said, "You can't always get what you want, but if you try, sometimes you just might get what you need." And boy, oh boy, do I have what you all need today. Superstar attorney, and he is back with us again. We are so lucky, so fortunate to have Mr. Mario Varela, my good friend Mario. Welcome to the show.
Thanks for having me, John. Thanks again.
Yes, sir. Hey, so today we were going to talk a little bit about business litigation. Despite our best efforts, sometimes in business, we end up in litigation. It's not what anybody wants, but, necessary evil. So tell us, if you can, please, what are some common causes of business litigation? How do businesses end up fighting each other?
By far, the first one would be breach of contract. Somehow, in one way or another, two parties or more parties start working on a project or make a promise to each other to do certain things in exchange for payment, usually. And somehow along the line, things start going all right, and they need to determine, first of all, where they will continue doing business. Of course, first thing to do would be to try to correct the situation, correct course, and go back to where things were running normal. Communication very important. But occasionally, there are cases where you can see fraud. You can see sometimes the other party is unable to to comply with the contract requirements, for example, payments. Sometimes you can see bad faith from the other party. And so there's a number of things that could happen. But by far, breach of contract is the largest classification of causes for business litigation.
Yes, sir. Well, we understand that. So that's word to the wise out there. Don't be breaching your contracts. Stay out of litigation. But however, sometimes it's going to be unavoidable. We can't help it. So let's say that I'm a business owner and I see that some litigation is coming down the road. It's coming right at me like a freight train, and I'm not going to be able to avoid it. I know it's coming at me. What can a business do to potentially prepare if you see litigation coming your way?
Well, I think it's very important to have an attorney involved early in the process whenever there starts whenever the owner or the company starts hearing about or anticipating possible litigation. There's a number of things that need to be done early in the process, from saving evidence and getting a good understanding of what's happening, especially a good understanding of whatever contractual obligations there are, whatever has been agreed in the contract. And remember, a contract can be verbal, it can be should be ideally should be in writing, but occasionally there are some agreements, side agreements that are done verbally. So that's why we have to take all that into account. And also remember, sometimes we get litigation cases against us, but also if we are working with another company and we see some form of breach of contract, we're not satisfied with how things are happening, we also need to look at the possibility of filing a lawsuit. Now, normally we want to negotiate and talk to the opposing party, to the other party first, to see if that's something that we can solve without having to go to litigation. And normally the managers would get involved at that stage to see if there's anything that can be done. But once that fails, really top management should make a decision on whether or not to go into litigation. When a company receives or starts to hear some form of complaints and demands that the company knows they're not going to be able to meet to comply. That's when litigation, we can say that litigation's on the horizon, so we need to start uh, acting proactively. I mean, working proactively to resolve those disputes or complaints. And if that doesn't work, then that's the time to move on and go to the next phase, which is start preparing for litigation. Normally, there will be a demand letter where, which is probably the first sign that the each one of the parties is getting serious about filing or starting the litigation process.
Man, that is some very important and great information, and we do thank you for being with us and for sharing all of that. I'm sure it's going to be really useful to folks out there. And so, let me ask you this now. Let's say that you got some kind of dispute on your hands, and I remember, back in law school, they told me a bad settlement is better than a good lawsuit 7 days a week. Right? And so a good lawyer will try and keep his clients out of court rather than in court. So you try and stay outside that courthouse. And so, what kind of strategies could you employ? So, say you're a business owner, you see some kind of dispute taking place, things are going from bad to worse, but you want to put the brakes on that. How could what kind of strategies could you use to effectively resolve these business disputes?
Well, there's always the option of some alternative methods of dispute resolution. The most common are mediation and arbitration. Now, normally we'll go and see in the contracts if there's provisions for using those forms of dispute resolution. And even if we go to court, many times the judge will send the parties to go to mediation just to see if they can settle the into an agreement as far as with their dispute. And John is very correct. There's a level of um, how can I say importance there in finding a agreement, some sort of settlement agreement that will make the dispute go away. And the reason for that is the certainty. When we are mediating, we are negotiating with an offer, with a demand, and a counter offer, going back and forth until both parties, hopefully, they will agree to some sort of settlement. And that could be even without admitting any sort of fault or any sort of liability, just to make the dispute go away. It could be for maintaining good customer relations. It could be just because both parties know that it would take a long time to solve the problem through courts. So for a number of reasons, the both parties can agree to a certain amount that will be used as the settlement to take care or to resolve the dispute. Now, and the reason for that is the importance of that method is the certainty. Normally, in mediation, none of the parties is going to get away with whatever they were wanting. Of course, the party that's unhappy with the contract, with the performance of the other party, probably wants a certain amount. And of course, the other party that's on the defense side, they're probably wanting to get away without paying anything. So many times it will be something in between, but it is something that both parties have accepted, they have negotiated, they can live with, and they know that in mediation there's no way one party will come out perfectly happy with the results, but there'll probably be two parties that are somehow, I mean, somewhat unhappy, but they can live with the settlement agreement. Because if for any reason they don't go into, they're not able to they're not able to get to a settlement. The next step will be go to a trial, and in trial, at the court, the judge may rule one way or another, and it could be 100%, 0%. Sometimes there are some additional expenses unanticipated. So there's a number of things that could happen that we really have not much control. Even if we feel that our case is strong to go to court, uh, there can be surprises in court, and there's that uncertainty that we're trying to avoid when we go to mediation. Arbitration is a different process, and normally it's spelled out or is required by contract, and it says that essentially we're gonna go to a process similar to a trial, but we're gonna let a arbitrator solve it or make a decision. Normally, those arbitrators are former judges, so they understand a lot of the law, and but that's something that's done outside the legal process.
Right, right. Well, hey, Mario, you know, a judge once told me, you know, justice has been done if everybody walks away just a little bit unhappy. So, you know, I word to the wise, if you're in a dispute, mediation, arbitration, and just try and get what you can get and get out of there, move on with your life. So we really appreciate all your great advice and knowledge here today, Mario. And please tell everybody out there, how could they get a hold of superstar lawyer Mario Varela if they want to call you, they want to consult, they want to talk about their legal situations? Well, how would they do that?
Yes, best way to reach us is by calling 713-684-3550. Our office is here in Houston, and we'll be happy to talk about your case and how we can assist you.
Perfect, perfect. So you folks out there, you heard it. Give Mario a call. You are going to be in good hands. And so we thank you again for being with us today, Mario. We are going to go to a quick commercial break, and we will be right back here on Legal Talk.
Thanks.